Mr. Mark, is President Trump eligible to run for president again in 2028?
Senator, without considering all the facts and looking at everything, depending on what the situation is, this to me strikes as more of a hypothetical of something that could be
It's not a hypothetical. Has President Trump been elected president twice?
President Trump has been certified the President of the United States 2 times.
Is he eligible to run for a third term under our Constitution?
I would have to review the
All I need to tell you.
In 1787, the founders built a system designed to stop tyrants. 2 centuries later, that system depends on one thing: people willing to enforce it. A Senate hearing just went off the rails. Judicial nominees, lawyers, judges, constitutional experts were asked point blank if the 22nd Amendment bars a sitting president from seeking a third term. The answer is 6 words long. It's written in plain English. Every law student knows it. But when Senator Chris Coons asked Trump's judicial picks to say it out loud, every single one of them refused. Not because they didn't know, because they wouldn't say it. What you're about to witness isn't legal confusion. It's calculated silence. And if you think that doesn't affect you, you're not paying attention. This is Liberty Code Network. Smash that like button, hit subscribe, and let's break down what just happened.
Chair.
Thank you, Senator Coons.
Thank you, Chairman Grassley, and to each of you and your families, congratulations. And thank you for raising your hand to serve and in some cases continuing to serve the public.
Thank you.
Mr. Mark, if I might, just tell me about the 22nd Amendment. What does it provide?
The 22nd Amendment, Senator, my career has mostly been in criminal prosecution. I haven't had an opportunity to use that one specifically.
Anyone able to help on the 22nd Amendment to the United States Constitution?
Well, Senator, I believe it is the amendment that deals with a 2-term limitation on
Correct.
the service
It
of the
states no person shall be elected to the office of the president more than twice. Mr. Mark, is President Trump eligible to run for president again in 2028?
Senator, without considering all the facts and looking at everything, depending on what the situation is, this to me strikes as more of a hypothetical of something that could be.
It's not a hypothetical. Has President Trump been elected president twice?
President Trump has been certified the President of the United States 2 times.
Is he eligible to run for a third term under our Constitution?
I would have to review the
All I need to tell
wording
you
of
is
it.
the language of the constitutional amendment that makes it clear that no, he is not eligible to run for a third term. Anybody else brave enough to say that the Constitution of the United States prevents President Trump from seeking a third term? Anybody willing to apply the Constitution by its plain language in the 22nd Amendment? Nobody. All right, let's move on. Mr. Coons, what is res judicata? How does it apply?
It's a judicial doctrine that prevents a judgment that has been, in one case, applies to a, you can't go into court after a final judgment in one case and have it, and litigate the same things again.
How is that distinct from collateral estoppel, which precludes litigating the same things?
Res judicata, one involves the same party, the other involves the same things.
And what's a requirement for these 2 doctrines to apply?
Notice, opportunity to be heard, final judgment of a court of competent jurisdiction.
Anyone disagree? If I might, Mr. Coons, is it pronounced the same way mine is?
Yes, it
Coons?
is. Yes, Senator.
My family's name was spelled that way when we came to the country. So, you were one of 3 judges on the panel in Alexander v. Trump, where the president was suing the Pulitzer Prize Board for defamation. When did your work on that case begin? When were you assigned this case to decide?
I first learned of that case in approximately January of 2025.
Not when the briefs had been filed?
No, Senator. The way it works in our court is we are not assigned cases when the briefs are filed. Once the case is ready for disposition, the clerk randomly assigns it to the judges in the court.
And when did you first speak to Senator Scott's office about your interest in a district court seat in the Southern District of Florida?
I mean, I've had many conversations with Senator Scott's office. The one about an interest in the Southern District of Florida, I believe, was in November of 2024. I don't know the date, but it's in my Senate Judiciary questionnaire.
And when did you release the opinion ruling in President Trump's favor in this matter?
So I learned of the case in January of 2025, and the opinion was released in, I believe it was February 12th, 2025.
That's correct. So you issued an opinion where one of the litigants before you was the president and in favor of the president while you were in active conversation with the senator's office about seeking a federal judicial appointment. Is that correct?
For a position I did not, in fact, get, Senator.
How did you end up in front of me today?
It's a different position, Senator.
Did you consider recusing yourself from that particular decision?
No, and the canons that govern us in Florida, Senator, as I believe this committee has previously heard, it did not call for me to recuse myself. I did not have an interest in the litigation, and none of the basis called for recusal, and the Florida Supreme Court instructs us, the appellate judges, that we are not to recuse unless one of the bases in Canon 3 exists.
Does the Florida canons not require you to recuse if one of the parties before you has an interest that could be reasonably concluded by any common citizen to cloud your judgment on that matter?
Senator, I disagree with that characterization. I had not heard from the White House until after the opinion was final. I had only spoken.
When did you interview with the White House counsel's office?
At the end of February of 2025. I don't know the date, but I believe it's in my Senate Judiciary questionnaire.
Thank you for your testimony on that matter. Mr. Hendershot, if you would just take a minute and talk me through again how collateral estoppel and res judicata are different from each other.
Senator, I'm not sure I can improve much on Judge Coons. I think that often res judicata today is used as sort of a catch-all term, but generally I think the difference is between claims and claims that may have not been brought but could have been brought potentially.
Right.
So collateral estoppel and res judicata is more of a thing actually decided, as the Latin would suggest.
Thank you. Do you agree that judges should not be influenced by external pressure to rule in any particular way?
Yes, Senator, I do.
President Trump stated March of this year at a public event, quote, "We have rogue judges that are criminals. They're criminals, what they do to our country, the decisions they hand down and hurt our country. Is it possible for a judge's decision to be correct as a matter of fact and law, even if it differs from the president's desired outcome?"
Senator, I want to tread carefully because of Canon 5 in terms of commenting on political matters, but in the abstract, yes, decisions can be correct, and any citizen can criticize what a judge has done. That is, I think, part of their right to speak.
Thank you. Thank you all for your testimony.
Yeah. Mr.
Let's walk through what just happened. Senator Coons asks, what does the 22nd Amendment say? Mr. Mark, a career prosecutor, admits he hasn't had occasion to use it. Fair enough. Not his field. But then the follow-up, is President Trump eligible to run again in 2028? Silence. Deflection. I'd have to review the facts. Here's what they're not telling you. There are no facts to review. The text is clear. No person shall be elected to the office of president more than twice. Trump has been elected twice. That's it. That's the analysis. But not one nominee would say it. Not one. Now ask yourself this. If they won't apply the Constitution when it's this clear, what happens when it's not? This is where it gets serious. These aren't random lawyers. These are judicial nominees, people seeking lifetime appointments to interpret and enforce the law. And they just demonstrated they won't do it when it's politically inconvenient. We've seen this before. Not confusion. Controlled hesitation. In these hearings, every answer isn't just legal, it's strategic. These nominees aren't just explaining the law. They're navigating a system where future appointments, political alignment, and perception all matter. If you're paying attention, you'll catch this. The evasion isn't random. It's structural. Judicial nominees are auditioning. Not for the Senate. For the executive. They know who's watching. They know what's rewarded. So they hedge. They deflect. They refuse to state the obvious. And the Constitution? It becomes negotiable. Let's keep going. Judge Coons. Different person. He sat on a panel in Alexander versus Trump. Defamation case. Ruled in Trump's favor. Nothing wrong with that. If the law supports it, the law supports it. But here's the timeline. November 2024. Expresses interest in a federal judgeship. January 2025. Assigned the Trump case. February 12, 2025. Issues opinion favoring Trump. Late February 2025. Interviews with the White House. Senator Coons asks, did you consider recusing? Answer, no. Florida canons didn't require it. Technically permissible, optically devastating. Now ask yourself this. If clarity creates consequences, what does silence create? Flexibility, ambiguity, protection. And that's the incentive. Here's what that costs you. When judges won't apply clear law, vague law becomes a weapon. When nominees won't defend limits on power, those limits erode. And when accountability depends on courage, and courage is punished, you get exactly what we just saw. Silence. This is the long game. This is how republics drift. Not through coups, through small surrenders, through smart people pretending not to understand plain language, through institutional actors choosing ambition over duty. No one explicitly denied the Constitution, but no one firmly applied it either. That gap, that space between knowing and saying, is where institutional doubt begins. And it doesn't happen loudly. It happens like this, quietly, carefully, in moments most people overlook. This isn't about Trump. This isn't about Coons. This is about a system where ambition shapes outcomes, where silence protects careers, where constitutional clarity becomes, I'd have to review the facts. So here's the takeaway. The system doesn't fail because bad people break the rules. It fails because good people won't enforce them. And if the people enforcing the law won't say what the law says, the law is already gone. That's not cynicism. That's pattern recognition. If this matters to you, hit like, subscribe, drop a comment. Let's keep watching.